appeal in the matter of Batistas and Betta Oceanway Company and another.
Yes.
My ladies, my lord, may it please the court. Morning. I am Georgios appearing for the applicant and appellant, Mr Vatistas, with Dr. King's counsel, and Mr Paul Bonner Hughes. Mr McCord Fritz, King's counsel, and Ms Thompson appear for the defendant and first respondent, forgive me, in this appeal, Tomini. Mr Reed and Mr Samuels appear for the claimant and second respondent in this appeal, Betta. Can I just confirm that you have before you the materials that the parties have submitted to the court? You should have each of the following: the core, forgive me, appeal bundle, a supplemental bundle, the joint authorities bundle, and the supplemental legal authorities bundle, which is very slim indeed. It only contains one case. I should...
Before we start, first of all, may I thank everyone for sitting at 10 o'clock rather than 10:30. I hope it didn't inconvenience people with their travel arrangements too much. We will need to finish a few minutes before 4 o'clock, which is why we're sitting at 10. But we have all had an opportunity of reading extensively into the case. So I think for my part, I don't think there's going to be any difficulties in comfortably finishing within the day.
I'm most grateful for this indication, my lady, and I should therefore indicate that the council teams in the room propose, subject of course to the court's direction, to split the time evenly as between Mr Vatistas and Tomini, up to 2 hours each, of which I will try to save some for reply, and for Betta to have 30 minutes or so. And this, my lord, my ladies, does reflect where the center of gravity in this debate lies. Betta does consent, the claimant does consent to Mr Vatistas' joinder, subject to some case management points to which I hope to come. Tomini, the respondent, does not. My ladies, my lord, the court's leave to appeal, which you have core bundle tab 11, page 125, records as the key point in this case whether Mr Vatistas should be permitted to intervene in order to ensure that the court does not lend itself to a fraudulent scheme. And the court below, Mr Stephen Hofmeyr, King's counsel, sitting as deputy judge, refused to allow Mr Vatistas to join as an additional defendant. I pause here to stress the words "in his own name." In the proceedings between Betta and Tomini, Mr Vatistas proposes to join in his own name, acting for his own account, and carrying responsibility for his own costs. We respectfully submit that the learned judge erred in 4 major respects. First, he was wrong to hold that it would be a subversion of the normal principles of company law to allow a minority shareholder or a former company director to join in his own name, I stress these words again, to join in his own name in court proceedings where the company is a party. That, we say, is an error of law. It's the wrong inquiry altogether. Secondly, the learned judge was wrong to evaluate Mr Vatistas' case by conducting a mini-trial, although without saying so in so many words. And we say, and Tomini agrees, I take that, my lord, my ladies, from the respondent's notice, core bundle tab 12, page 128. We agree that the applicable standard was whether or not the Batistas case was properly arguable. Again, that was an error of law. And thirdly, we go further to say that had the judge applied the proper arguability test, Mr Vatistas' case would meet it. Mr Vatistas' case does meet it, and he should have been joined. And this, we say, is an error in the application of the law. And fourthly, we say that the court below erred in failing to identify, altogether to identify, the risk of abuse of the court's process that is present here and how it may be and must be averted. The risk is that, on Mr Vatistas' case, the court is bound to pronounce as legally valid and enforceable putative debt instruments which were knowingly based on the falsehood that there was a debt to record in these instruments in the first place, while in truth there was not. The judge, for his part, thought that even if the Batistas case is true, it is not the court's responsibility to ensure that it hears and determines the case for falsehood, but it is the duty of the respondent itself, Tomini, or a Romanian valuation court to do so. That holding, we respectfully submit, is a failure to consider a highly relevant factor in the present circumstances, a paramount factor in applying a multifactorial test under CPR Rule 19.2, paragraph 2. My ladies, my lord, to make good on these 4 key points, it seemed to me helpful, entirely subject to the court's preference and steer, to organize my submissions in 5 parts. First, to describe what the Batistas case is and what it is not. It is a necessary framing point because it seems to be some confusion about this. Secondly, to describe the applicable legal test under Rule 19.2, paragraph 2 of the CPR for a party to be joined in proceedings as an additional litigant. And I note parenthetically that, as the court will have seen, we have also sought intervention on the basis of the broader power of the court in Rule 3.1, paragraph 2. Now, I'm happy to explain the historical procedural reasons which lead to that. They're rooted in directions of a tribunal, an arbitral tribunal below. But as the case has evolved, it has appeared to us that Rule 19.2, paragraph 2, is the more appropriate route for Mr. Vatistas to join in the proceedings. That would be the appropriate procedural rule and the procedural label. What he does in the proceedings, we will come to discuss. So we are prepared to withdraw our reliance and narrow the debate. Therefore, Rule 3.1, paragraph 2 will not feature in my submissions. Now, having dealt with the legal test, I will then, this will be my 3rd part, address appeal ground number 1, that the court below failed to identify the legal test in the 2 respects that I've just indicated, the subversion of company law, which is the wrong inquiry, and in failing to apply the properly arguable case test. The 4th part concerns, forgive me, our appeal ground number 2, that the court below failed to consider the risk of abuse of process, failed to identify the risk first, and then to address its mind to it. The 5th and final part will be very short. It concerns case management, that is to say, how Mr. Vatistas will participate in the proceedings. My ladies, my lord, I propose not to address at all, at least in opening and subject to questions, but leave to the skeleton argument, paragraph 69 to 70, which you find core bundle, pages 157 to 58. Our appeal ground number 3. This concerns the learned judge holding that Mr. Vatistas should have asked for strikeout rather than joinder. This is a very simple point. The judgment below, I say with respect, has it backwards. Mr. Vatistas could have asked for strikeout only if and after he had been joined in the proceedings, but he was not. I gather from my learned friend's skeleton argument, core bundle, tab 14, pages 180 to 181, paragraphs 56 to 57, that this debate doesn't require much airtime today. It will not be a hard-fought battle, and not very much turns on that. My lord, my ladies, I come to the 1st part of my submissions. I can be short. What is the Batistas case? It is that the alleged debt of 194 million Romanian lei, or about $40 million to make things simpler, for which Betta asks the court to issue declarations of legal validity and enforceability. You have that in the particulars of claim, core bundle, tab 8, page 94, paragraphs 86.1 and point 2. That alleged putative debt does not exist, and that the 2 putative agreements which purport to memorialize such a debt, which are purportedly dated 2015 and 2016, you find them in the supplemental bundle under tabs 11 and 17. These agreements were known falsehoods signed in order to avoid, or rather to continue avoiding, from 2009, a potential tax liability for Tomini in its country of incorporation, which is Romania. These 2 putative documents or putative instruments are stated to be governed by English law, and they provide for LCIA arbitration or English court jurisdiction, which is why, my ladies, my lord, we're here before you today. Now, Mr. Vatistas says, and I'm oversimplifying and omitting very much, that a debt of about $40 million could indeed not exist in 2015, 2016. Why? Because the original holder of that debt, a Panamanian company called Sovereign, owned by Mr. Imtiaz, forgave about 90% of the nominal amount and sold to Bettas, the claimant's predecessor, 10% of it at its face value. And so only about $4 million survived. The accurate figure, to which we will come again, is $3,945,000. Mr. Vatistas says that there was a further separate agreement that this remaining amount would not be repaid, but that was a collateral agreement between him and the owner of Abbottswood, and who is also the owner of Betta, the claimant. But that is a detail and it's not crucial for present purposes. So with the permission of the court, I will not dwell on that.
So what is it that's the further agreement not to repay even the $4 million?
Correct.
Okay.
It was regarded, says Mr. Vatistas, and you will find this in his first witness statement, supplemental bundle, tab 39, paragraph 18, which is over 2 pages, 234 to 235, my lord. He says that the 4 million, some of which was debt acquisition but debt not to be paid, and 55,000 together making a cool round 4 million, was the price that Mr Diab, who is the owner of the claimant, Betta, but also the owner of the respondent, Tomini, through a company called Abbottswood. So Abbottswood is the participant in these agreements back in 2009. Mr. Vatistas says that 4 million was the price that Mr. Diab was willing to pay. And as I say, there is not very much of great importance for today's purposes in whether this 3,945,000 ought to be repaid or not. The discussion is really about whether of the 40 million original debt, 100% of it survived and could have been assigned, or only 10% of it survived and could have been assigned. So all of this, as I was saying, happened back in 2009. This is uncontroversial, forgive me. When Sovereign decided to exit the scrap metal business, which it was conducting with Tomini, in order to focus on its own shipping business, which it still conducts to this day. And Sovereign accepted, as part of that, that this exit would be at a loss in the aftermath of the financial crisis of that time and the collapse in the prices of scrap metal. As I say, I am being very elliptical and as economical as I can, giving you just the nature of the Vatistas case, because that's what is important to understand at this stage. I should also indicate upfront that the existence of this alleged putative debt from 2009 onwards is not a pure assertion, and I will come to make good on this ever so briefly, but I will. Now, why is the known falsehood which Mr. Vatistas' case pleads legally significant? Because, and this of course is not contested, shams, as we call them, or some systems call them simulated agreements, fictitious agreements, documents executed by parties intended to give to third parties or to the court the appearance of creating between the parties legal rights and obligations when none exist, or which are different from the actual legal position, these are invalid and unenforceable. That is why the Vatistas case is legally significant. The question of legal validity and enforceability of these, as Mr. Vatistas says, sham instruments, is squarely before the court. It is the principal relief that the claimant Betta asks the court to grant to declare these putative instruments, these two instruments from 2015 and 2016, as legally valid and enforceable. This question, my ladies, my lord, is not pending before any other forum. It had been brought to an LCIA arbitration, which is still on. The tribunal is on tenterhooks awaiting this court's decision. But it is not pending before any other court, nor can it be pending in any other court because there is an exclusive jurisdiction clause. Now, there is, to be sure, a court proceeding in Romania. The judgment refers to it as the valuation proceeding, where the assets and liabilities of Tomini are being valued. It is Mr. Vatistas' evidence that what the English court decides as to the validity and enforceability of what we say are sham instruments will be an important factor in determining the company's liabilities. Why? Because the accounting records, which show an amount, will or will not be shown to have been accurate or inaccurate. Now, as to what the Batistas case is not, Mr. Vatistas' case does not go into matters between shareholders of Tomini, into legal matters, I mean, nor does it go into legal matters of how the Tomini company directors exercise their duties. The relations between the Tomini shareholders are governed by Romanian law. The directors of a Romanian company are also governed by Romanian law, and their duties are governed by Romanian law. The court has received no evidence of Romanian law on such matters. The court is not asked to make any pronouncement on such matters of Romanian law. The court is asked to pronounce on the legal validity and enforceability of the putative debt instruments that I mentioned. I wish this, and forgive me for dwelling on it, my ladies, my lord, I wish for this to be clear because of how Tomini's notice is formulated. Can I respectfully suggest that we turn it up?
Certainly.
Court bundle, tab 12, page 128.
So is this a skeleton argument?
It's Tomini's respondent's notice, my
Right,
lady.
thank you. Sorry, give me that reference again, would you please?
Court bundle, tab 12, page 128. So it's internal page 3 of the respondent's notice. And if I may direct attention to the second paragraph from the third line, you see there that Tomini suggests that the judgment of the court below should be upheld on the basis that Mr. Vatistas did not present a properly arguable case. This is where Tomini and we agree upon the arguability standard, at least as stated here.
I'm so sorry, I haven't got any tabs. I haven't.
Page 128, my lady, core bundle. That should work even if they're not.
Yeah,
not
it should.
It should. If it doesn't, we make apologies and we can fix
No,
it.
don't worry.
Will it be helpful if I read it out
Yeah,
into
this
the
is
record?
Final call bundle. Sorry, page 128.
Yes, my lady.
Appears to be a transcript.
No,
Let me share yours. I'll
Exactly.
sort myself out.
you have a look at that, I've had a look.
The transcript ought to be in the supplemental bundle.
No, it's a titled core bundle.
Now we identified where the mischief is.
I'll sort myself out, don't worry.
It's my learned friend Dr. Ballard who did that last night.
Thank you.
If the court is there, we're at page 128 of the court bundle. This is Tomini's respondent's notice. It consists of 3 paragraphs. And I'm entirely happy to wait, of course.
I'm really sorry, someone has got my papers in a dreadful muddle because that is another case altogether.
We have another.
Authorities.
My lady,
Sorry, I'll
we-
have to get my clerk to come and sort this out.
We have another set which
Have
is
you? I
unmarked.
do apologise. I think I've been given the bundle for tomorrow.
No, this is your authorities are the children case.
Yeah, they're all the wrong papers.
Are you comfortable with that? It's unmarked. My lady, our learned friends agree that we should hand this up to you
Right,
on the
thank you very much.
understanding that it is unmarked.
To help him.
There's more.
Just go get it, would you mind?
There's more, sorry.
We have all of the.
Well, my bundles, which of course were marked up, will, my clerk, this will keep me going, and
Can we test whether the citation I gave you works?
let's do that.
Core bundle
I'm
page
so sorry
100.
to even,
Forgive me.
Feet of clay, very unusual. My clerk is breathtakingly efficient, so I can't think what's gone wrong. My apologies. I now have it. And I hope is this your junior's own bundle? Is it going to be a problem if I mark it up?
It will not be a problem.
Thank you.
It is not marked up. So, my lady, we are at Tomini's respondent's notice. Consists of 3 paragraphs. May I direct attention to the second paragraph? 3 lines from the top. You see there, Tomini suggests the judgment of the court below should be upheld on the basis that Mr Vatistas did not present a properly arguable case. That, and I quote, the claimant's motivation in bringing the proceedings was improper, or that the defendant's directors were not acting in the defendant's best interests. Now, Mr Vatistas does not plead such matters. Mr Vatistas' case need not plead such matters, nor could Mr Vatistas do so in the English court. Why our learned friends opposite think that he does plead such matters or that he ought to plead such matters is a matter for them. I am not entirely clear myself. Perhaps they will explain and then I will be able to reply.
I thought you did essentially say that. I thought you said that these proceedings are an abusive process because they are essentially a stitch-up to get your shares for nil value. So the English court has been asked to decide that there is no enforceable liability. Sorry, that there is enforceable liability, which will mean that the shares are not worth anything. Therefore, Mr Diab, is it, can get them for nil value. And if that that is saying that their motivation in bringing proceedings is proper, and that the directors are not acting in Tomini's best interests because they are admitting to a significant liability which they ought not to admit.
And that, my lord, is context. What Mr Vatistas says, and I wished it to be very clear for the court from the beginning, is that the risk of abuse of process present for the court is that the court is being asked, for reasons which may be good, bad, or indifferent, to declare as legally valid and enforceable putative agreements which were known falsehoods when they were executed. That is the risk of abuse. That squarely and simply, that risk of abuse does not require the court to consider the motivations for why the court is asked by the claimant and the defendant accedes to that request to rubber stamp these putative debt instruments. The issue is that the court is in fact asked to do that which on Mr. Vatistas' case is to rubber stamp known falsehoods or instruments predicated on known falsehoods, which are sham. My lord, my ladies, if I may, I now move to my second part, which is briefly to describe the framework of CPR Rule 1942. This rule will be better known to the court than to me. So I do this with some trepidation. And I will move on the instant I'm told to move on. Can I ask the court kindly to turn up the white book at page 550? We have, you certainly have copies, but
551.
my lady. Now, it is helpful, I respectfully suggest, to think of this rule as setting forth 2 tests. The first test is one of permissibility, and that asks whether the proposed new joiner comes within the gateway of this provision, and the gateway is either paragraph A or paragraph B. And the second test...
Sorry, could you just tell me which year white book you're looking at?
I thought it isn't on page
2025.
Lucky you is all I can say.
We have printed copies, my lady.
Good, because we're all looking at 2020 old books, which
The rule itself hasn't changed. Would it be helpful to the court if we handed up printouts of the
please. I'm sorry, this looks like an absolute shambles, but I can assure you that the Constitution, notwithstanding the bundles and the white books, has read all the papers and dipped into the authorities.
Rule 19.2 is on page 661 actually, in the volume that I have anyway. Thank you.
Thank you very much. You can scribble on this anyway.
So the first test is one of permissibility, a gateway which consists of two limbs. The second test is one of appropriateness. The second test is one of appropriateness, as I was saying. So that's after the gateway. And one can see this in the term desirable, which is used in both subparagraphs of paragraph 2. So I propose to address ever so briefly these two tests in turn, starting with the gateway. The gateway has two limbs. Each of the limbs is broadly formulated to encompass a variety of situations in which a new party may be joined in the proceedings. If I can ask you just to glance at each limb. The first limb speaks to the situation where in proceedings between A and B, C is to be joined so that the court can resolve all the matters already in play as between A and B. So one example, I have many, but one example is where C, the proposed joinder, wishes to join to assert that the legal interest in play between A and B is really its own interest. For example, there is a charging order dispute and the beneficial owner, C, turns up and says, I'm the beneficial owner in addition to the legal owner. The second limb, subparagraph B, speaks to the situation where there is an additional issue that C brings to the party. This is terminology used in one of the cases in the authorities bundle, which is why I adopted. So C says, I have something new to bring to the party, an issue which is connected to the issues already in play as between A and B, and that new issue may be resolved in that framework which is already extant before the court. So an example of that would be there is a dispute between A and B, but it is part of a broader dispute in a legal relationship, which involves also C.
What are the matters currently in dispute in the proceedings? I thought the whole essence of your complaint is that there is no dispute about this debt in the proceedings because Tomini admits it. That's why you say it's an abusive process. So,
Indeed, my lord.
Where does that take us in terms of this rule?
The short answer is that it is not required that a matter which is between A and B is contested, and I will come to make that good on the authorities, including authority of this court, the Court of Appeal. What is required is that a new issue, that the joinder of C, the third party, will contribute something to the issues, not the dispute, that are engaged in the proceedings between A and B. And I was proposing, my lord, I'm grateful for your question, to do this a little bit systematically by walking through the authorities ever so quickly. So we have two authorities in the record which address in systematic fashion Rule 19.2. One is a decision of this court in Re Pablo Star, Legal Authorities Bundle, tab 7, pages 139 and following. And the decision of the High Court by Mr Mr. Kimball, King's Counsel as deputy judge, which is called Molavi. That is the one case in the supplemental legal bundle between pages 2 and 10. I will be happy to take you to each of these cases in detail if the court wishes me to, but if I may telegraph for your notes that they spell out 4 points, my lord, and one of them is squarely the point that you just put to me. The first is that Rule 19.2, paragraph 2 is a broad gateway, which means that it is capable of being engaged in a broad variety of circumstances. In the Pablo Star case, at paragraph 51, page 150 of the bundle, this court said in terms that the provisions of the rule, I quote, ought to be given a wide interpretation. So the rule is permissive, it's not restrictive, which is why it is drafted in terms which are not entirely technical. The second point that arises from the authorities is that the term used in relation to both of the two limbs, that was the term your lordship brought to my attention, which is matters in dispute, is to be read broadly to mean matters in issue. And we have that, again, in the Pablo Star case, at paragraphs 50 and 52, pages 150 and 51 of the bundle. And if the court is happy to take my representation of what was happening in that case and why this was decided, in proceedings where the shareholders of a company were asking the company registrar to reinstate the company, and the registrar had no objection or difficulty, a third party, namely the Welsh government, appears and says, we object. To which the claimant in the proceedings, asking for reinstatement of the company, says, well, that issue is not in dispute. You have no place here. And because that kind of context arises frequently in a chancery setting, it went to the Court of Appeal, and the Court of Appeal said, matters in dispute ought to be read broadly as matters in issue. So in the proceedings between A and B, it is entirely possible for C to articulate a different view on a point that A and B treat as uncontested. And C's point may, but it does not need to be a cause of action against either A or B. So an additional defendant, as in this case, is a procedural label and a gateway for allowing a new party in the proceedings, and then exactly what the party, that party will contribute to the proceedings is a matter of case management. So the third point that arises from these authorities is that there is a degree of overlap or shading, I think, one authority puts it, between the two limbs, paragraph 2, although in principle, each of the limbs is capable of being self-standing and engaged on its own terms. But it is possible for both of the limbs to be engaged in the circumstances of a case. And the fourth and last point from the authorities is that there is a common core across both of the limbs in paragraph 2, which is that the new joiner, party C, as I was calling it, must in principle have a direct as opposed to an indirect interest which is affected, or which may be affected, as the Court of Appeal said in Pablo Star, by the outcome of the litigation between A and B. And one can obviously see the wisdom of this requirement of a direct interest, because otherwise parties indirectly affected, as was the case in Pablo Star, might be seeking to take court resources. My ladies, my lord, none of these four legal propositions is controversial. I don't think. They are each engaged in the present case in varying degrees, which is why I thought it might be helpful for the court to have them all in one place. I come now to the second test, which is after one has crossed the gateway. It appears to be uncontested that once that gateway, or one of the gateways, has been crossed, one turns to the test of desirability. And it is common ground that this assessment is multifactorial. But I trust there will also be no dispute that the factors which come within the notion of desirability are rooted into two basic sources spelled out by the Court of Appeal, to which I will come. And I trust also that there will be no debate that that two of these factors, which are part of the desirability test, are hard-edged legal tests rather than discretionary judgments. This is important in the present case, my ladies, my lord, because it appears that Tomini invites you to find that the learned judge below had simply an overall discretion, and the exercise of that discretion is reviewable by this court only if it has been, and I quote her term, perverse. That we submit is wrong. That is not the legal test, and I will come to make good on that. The salient case on which, on what this court called the two lodestars of the desirability test is re Pablo Star. May I ask that we turn to it? So perhaps we all have it in mind, but I will telegraph that the learned judge in the present case did refer to Pablo Star at paragraph 40 of his own judgment. So Pablo Star is at core bundle tab 6, forgive me, it is legal
Tab
authorities.
7, we already have it open.
You do.
Yeah, I'm showing off now, showing I can find my way around the bundles.
Tab 7 of the legal authorities bundle. The citation I had in mind, perhaps not so well in mind, is that paragraph 40 of the judgment below is core bundle tab 6, page 62. That is the paragraph to which the learned judge refers to Pablo Star. Thank you, my lady. And if we turn now to page 152 of the legal authorities bundle, this is Pablo Star. Paragraph 60 of the judgment, the court says this: in considering whether or not it is desirable to add a new party pursuant to CPR Rule 19.2, paragraph 2, two lodestars are the policy objective of enabling parties to be heard if their rights may be affected by a decision in the case, and the overriding objective in CPR Part 1. It may help, therefore, to think of joinder as a procedural institution which lies at the intersection of the private interest and the public interest. And I do not propose to dwell at any length on the factors which the courts in their practice have identified as relevant in assessing desirability. For example, the uniqueness of a party's perspective, or whether that perspective is in fact duplicative of perspectives already in play between the existing litigants, or what are the appropriate modalities for the joinder or intervention. I propose not to dwell on these matters because they are of no particular significance for the present case. I wish to focus only on two factors which are of key significance in the present case. As to the first lodestar, the right of access to justice, Tomini's notice now says, as I mentioned earlier, that this imports a filter of advancing a properly arguable case. So a properly arguable case is entitled to be heard by way of joinder. A case that is not properly arguable is not entitled to be heard. As to the
just to clarify, when you say properly arguable, should we understand that as the same as having a real prospect of success, which is
yes, my lord, the summary judgment test.
Commonly used
Yes.
phrase in court.
Yes, the summary judgment test, and I will come to spend some time.
Okay, you mean the same thing by
I mean exactly that thing.
that. Okay.
I'm grateful. As to the second lodestar, which is the overriding objective, there is no contestation that the court's duty to guard against the risk of abuse of its process is part of the overriding objective, or must be part of the overriding objective. So these are the two matters that I wish to identify, or two factors which I wish to identify for the court as having significance in the present case. And now I'm done with my framing points, and I move to our appeal grounds, if I may, my lord, my ladies. I wish to address our appeal ground number 1. First, that the court below failed to apply the proper legal tests under Rule 19.2, paragraph 2. Can I ask that the court kindly turn up the judgment below, which you find at core bundle, tab 6, page 63. Starting at paragraph 53, we have a section titled Analysis. Just to give to the court the lay of the land, this occupies about 5 pages of printed text. Forgive me, I need.
You said at 53, I think it's 43, is the paragraph immediately under the heading Analysis. Perhaps I misheard you.
Much more likely that I misspoke. I'm grateful for that. So starting at paragraph 43 indeed, the court below sets it out its analysis, or what it calls analysis here. This occupies about 5 pages of printed text, and you see that on the prior page, which is page 62 of the bundle, paragraph 38 and 40, the learned judge sets out the rule itself and 2 portions of this court's decision in the Pablo Star case that we looked at. What the learned judge then does not follow the 2-stage analysis of considering first the gateways, then the desirability test. So it is not straightforward, even attending to this sympathetically and with an open mind, to understand what test or rules the learned judge was proposing to apply. Be that as it may, in our respectful submission, the judge made 2 errors of law, which I propose to address in turn. The first error was to import an unwritten exception to Rule 19.2, paragraph 2. The learned judge said, this excludes minority shareholders from coming within the rule. The judge did say that this exclusion suffers exceptions, but he did not say what these exceptions may be. We know that Mr Vatistas was not within the exception, but we don't know why. So it is difficult, I say, with respect to understand the perimeter of the proposed exclusion and the exception of the exclusion therein. May I ask, please, that we turn to paragraph 44, forgive me, of the judgment. It starts with the words, the proceedings before this court are being conducted on behalf of the claimant and the defendant by the only bodies authorized by them to do so. And 5 lines down we read, to allow a minority shareholder a say would subvert the allocation of responsibility for the management of the corporate entity to the directors bestowed by the company's constitution. And if we skip 1 sentence, it is said that Mr Vatistas, as a minority shareholder, has no standing to bring any claims or advance any defenses. Permitting him to participate in these proceedings would be inappropriate because it would undermine and usurp the authority of the defendant's board of directors. And if we turn over the page 64 of the bundle, the same point is made about a usurpation, forgive me, of powers, paragraph 45, about 5 lines from the bottom of the paragraph. Then the learned judge turns to discuss the case of Abraj. This is a decision of the High Court, Mr. O'Sullivan, King's Counsel, as deputy judge, at paragraphs 46 and 47 of the judgment. At paragraph 46, the judge describes the facts of that case. at paragraph 47, which is now on page 65, first line, the learned judge says that in his view, Abraj was a case decided on its own facts. That is the first sentence of paragraph 47. He immediately goes on to accept, however, that, I quote, it identifies the relevant principles which the court must apply on a joinder application. So may I ask, now that we turn to Abraj, please, it's Legal Authorities Bundle under tab 14, starting on page 278. If I may, let me give the context which one can pick from the head note. The applicant was a board director of the defendant. The applicant was asking for a stay of the English proceedings that had been brought against the defendant until the courts of the Cayman Islands would have resolved the dispute about the deadlock of the defendant's board. The deadlock prevented the board from filing a defense in the English court. The claimant proposed, instead of a stay, that the director, through lawyers who had already been instructed, join in the proceedings via Rule 19.2, paragraph 2. But then the applicant insisted on a stay and objected to joinder on what the applicant submitted was a principle of company law. In the interests of taking this, my ladies, my lord, as economically as possible, may I ask you to turn to page 299 of the bundle, paragraph 113. The court says, plainly, it does not follow that a director can never be joined as a party to proceedings involving that company. Nor does it mean that no one can ever be joined as an additional defendant to a claim in which a company is the defendant. The claimant's proposal does not involve the applicant or the original shareholders defending the claim in the name of the defendant. It envisages the applicant, and or the original shareholders filing evidence and making submissions in their own names as, in effect, interested parties in relation to that dispute. The court elaborates on this point, paragraphs 114 to 115, which I'm entirely happy to leave to your notes, if I may. It recognizes that its power to join third parties in proceedings directed against that company is to be exercised in special circumstances. This you find, my ladies, my lord, at page 300.
Yeah.
Paragraph 115, marginal letter A, in special circumstances. In the interest of being extremely practical, let us put to one side the question whether it's right to adopt the Abraj approach, which is that joining a shareholder or a board director or a former board director, someone who is internal to the company, shall we say, as a party in its own name is unproblematic, that is what Abraj says, but it's to be done in special cases, or the learned judge's approach, which is such a joinder is deeply problematic and should be allowed only in exceptional cases. Let us assume, I propose that we do that in the interest of being practical. Let us assume it is just a difference of emphasis rather than substance. That the special cases and the exceptional circumstances may meet at some point, whether one starts from premise A or the opposite of A. If that's the case, if the learned judge in our case had Abraj firmly in mind, in fact he did say, as I showed to the court, that Abraj lays down the principles that must apply. This was at paragraph 47 of our judgment. if that were the case, then one would have expected the learned judge to have regard to the range of factors that the Abraj court took into account. Can I please direct attention to them if you still have the Abraj case open before you? First, paragraph 45 on page 286. The court here notes that it should proceed on the basis that there might be a properly arguable defense to the claimant's claims in these proceedings. Then to paragraph 77, which is page 292, and continues over to page 293. The court observes there that the reason that the board became deadlocked may well have been that a director proposed to advance a defense to the claimant's claim. The claimant in that case was also the controlling shareholder of the defendant. But once that had been done, the board was deadlocked. Then on page 296, paragraph 95, the court says, at the heart of the applicant's argument is the proposition that unless a stay is granted, there cannot be an effective determination of the issue as to whether the debt is due and owing. We can all agree that if the defendant is deadlocked and in practice unable or unwilling, and I stress unwilling if I may, to defend itself, that would be unsatisfactory from the perspective of getting to the right answer. The applicant's best point is that if it was subsequently decided in the Cayman Islands that the defendant should have appointed lawyers to dispute the debt, it would be disappointing if there had already been a final resolution of the question as to whether the debt is due and owing on the basis of a one-sided hearing. And lastly, if I may ask the court to turn to paragraph 111, which is on page 299. The court also regarded it as significant that the claimant in that case was consenting to the joinder of the board director. Or
Well, it's actually a case where the claimant was proposing the joinder and the director was saying, no, I don't want to be joined, and in fact, you've got no power to join me. I demand a stay.
Entirely so, my lord. The claimant in that case was saying, you say you have a case, let's hear it, let's have it determined. And the respondent was, the applicant in that case, was appearing to simply want to prolong the agony, send the matter to the Cayman Islands, where it was already pending as to the deadlock of the board, wait the outcome there, and then come back to the English court only later. So the learned judge says, the important thing is to get to the right answer. And if we can hear both sides of the debate on the right answer, that is desirable. And as I mentioned a minute ago, paragraph 111 states that the court considers it significant that the claimant is consenting. Why is it consenting? Why is it important? Forgive me, my lord, my ladies. If the claimant is prepared to meet a second defense, in the present context, the only defense, how can it be said that the defendant is being prejudiced by an intervener who is articulating that defense? If the defendant is conceding the claimant's case, as here, then if the intervener is right, the defendant will be better off. If the intervener is wrong, then the defendant will be in the same position as where it started.
Well, it would have incurred a lot more legal costs for a start. How would you deal with that situation?
Which may be dealt with in the proceedings, my lord, and I was about to make that point very clearly when we would come to procedural legality. As a additional party in the proceedings, Mr Vatistas would be subject to the normal rules of costs as everybody else. No one is suggesting that this be a free party at all. And so all of those factors that I just took the court to in the Abraj case are extant in the present case as well. and in particular, the fact that the claimant, Betta, also consents to Mr. Vatistas' rejoinder. It is prepared to meet the Vatistas case. It does not make any objections as to his participation based on any principle, real or imagined. And this is important for a philosophical reason, which is the claimant normally chooses who the defendant will be. The claimant in this case says, I am happy to treat the intervener, Mr. Vatistas, in effect, as an additional defendant. So, as I say, the learned judge did have Abraj in mind. He said that Abraj identifies the principles to be followed, but then dismissed it as a one-off case without considering the close and important analogies with the present case. My ladies, my lord, that concludes developments on the first key error I wish to draw attention to. I come to the second major error of law, if I may, which is that the learned judge failed to apply the right standard to the arguability of Mr. Vatistas' case. We accept entirely, of course, as I said earlier, that there is an arguability filter to be met as part of the desirability assessment. That was stated, as we saw in the Abraj case, paragraph 45, page 128 of the bundle. It was stated as the properly arguable case. Now, in a more recent case, simply so you have this additional reference, the test was formulated in equivalent terms as, I quote, does the case against the party to be joined have a real, as opposed to fanciful, prospect of success? That case is called Wise Payments, Authorities Bundle, tab 15, page 310, paragraph 37. I'm happy to leave it to the court's notes, so turn to it entirely in your hands. If I may, it is important that we go a little into the precise content of the properly arguable standard text, and I will be entirely at the court's disposal to move on, because the authority is bound to be better known to the court than it is to me. That is the Okpabi case in the Supreme Court, Legal Authorities tab 11, starting at page 226. So that case is guidance as to what the standard requires the court to do, and most importantly, what it does not allow the court to do. This was a case, you can pick that up from the headnote, concerning whether or not service out of the jurisdiction should be allowed in respect of a Nigerian subsidiary of Shell that was alleged to have been negligent in respect of serious environmental harm. This point remained live up to the Supreme Court. The environmental harm was in Nigeria. If I may ask the court to turn, please, to page 230 at paragraph 10. The judgment of the court is by Lord Hamlin. The court there says, this is around marginal letter D, that in order to establish jurisdiction, the claims asserted must, I quote, raise a real issue to be tried, which means that they have a real prospect of success, comma, the summary judgment test. So the summary judgment test asks whether the case, as pleaded, must be dismissed without trial. The court then goes on to explain how this test is to be conducted. This is at page 232, if I may ask you to turn to that, paragraph 22. From the beginning of the paragraph, the court says, where, as will often be the case, where permission for service out of the jurisdiction is sought, there are particulars of claim. The analytical focus should be on the particulars of claim and whether, on the basis that the facts there alleged are true, the cause of action asserted has a real prospect of success. Any particulars of claim or witness statement setting out the details of the claim will be supported by a statement of truth, save in cases where allegations of fact are demonstrably untrue or unsupportable. It is generally not appropriate for a defendant to dispute the facts alleged through evidence of its own. Doing so may well just show that there is a tribal issue. And I place considerable emphasis, if I may, on the last sentence of paragraph 22. And if we also turn, please, to page 248 at paragraph 107, this is about the exception to the rule that the court must accept the case as pleaded and the witness statement as given. So what is said here, paragraph 107, is, and this is at the end of the paragraph, the factual averments made in support of the claim should be accepted, unless, exceptionally, they are demonstrably untrue or unsupportable. And at paragraph 110, this is still on the same page, the court quotes, this is at the end of the paragraph, 3 lines from the bottom, from an earlier judgment of the Court of Appeal, factual assertions do not have to be accepted by the court if it is clear that there is no real substance in them, particularly if contradicted by contemporary documents, i.e. if they are demonstrably unsupportable. And the final piece of the jigsaw, my ladies, my lord, is to be found at page 252, paragraph 128 of the judgment, marginal letter D. The court there says that one further question to ask in this inquiry is, are there reasonable grounds for believing that disclosure may materially add to or alter the evidence relevant to whether the claim has a real prospect of success? So in short, the test is this: A, is the case as pleaded and taking it as true a case that can be dismissed without trial, i.e. does it not disclose a triable cause of action or defense? As an exception, the case will not be taken as true if it is demonstrably untrue without trial, especially in the light of the contemporaneous documentary evidence, or if it is incapable of being supported. And C, in considering whether the case is capable of being supported, the court ought to address its mind to the prospect that the case might be materially, added to or altered in the course of disclosure. And it may be helpful to indicate that as to this last point, our learned friends say that the prospect of disclosure must be concrete in terms of identifying the nature of the evidence that will emerge and the issues to which it will go, and we accept that. So now that we have that framework, can I ask that we turn to the judgment of the court below again to see what the learned judge actually did? If we can pick up the judgment for bundle tab 6, page 66, paragraph 53. This, my ladies, my lord, is the one paragraph where the judge deals with this issue. He starts on page 66 by saying that Mr. Vatistas says there is no debt owing. The defendant says it is owing. The judge then correctly says this is not a dispute that he can or should attempt to resolve. Then he says, third sentence, nevertheless, the strength of the assertion is a matter to which the court can and should have regard in exercising its discretion. Now, this sentence does not identify a legal standard. It just says that the court may assess the strength of the assertion. The problem is, of course, what it doesn't say, which is the court must take at face value the assertion, as we saw in Okpabi. It seems, I'm just taking the words of the judgment of paragraph 53, it seems that the learned judge was applying a discretionary test in evaluating the evidence that was before him. And what follows in the paragraph, which I would invite the court to read, has the hallmarks of being a mini trial. It consists of just a few sentences, which go over to page 67. And the conclusion of the exercise is at the end of paragraph 53 on page 67. the learned judge says that the Batistas case is, I quote, weak, and I quote again, unsupported by any clear contemporaneous documentary evidence. I place emphasis, if I may, on clear. So the judge did not, as he was required to, take Mr. Vatistas' evidence as true. In fact, he seems to have required clear contemporaneous documents to support the witness evidence before accepting it. And that was manifestly the wrong approach to the arguability test. So when one reads these conclusive sentences at paragraph 53 together with the preceding sentences, it seems that the judge was saying in this paragraph that some of the documents speak in Mr. Vatistas' way, but the weight of the document goes the other way, and that is not enough. In our respectful submission, that is a mini trial on the preponderance of the documents at this initial stage, before disclosure, before the witnesses who will be submitted to cross-examination on matters which are serious, which will go to the integrity of the witnesses and the honesty of the witnesses as to whether or not they were recording falsehoods in a document that purports to appear to the court and to third parties as a legally binding document. These will be very serious matters. But
I think you said that the judge was saying that some of the documents support Mr. Vatistas' case. Perhaps you could identify those in a moment. I thought the point made against you was that none of the documents support his case, to which your answer is, well, if it was all a tax fraud, you might not expect to find a big documentary trail. If you're saying that there are some documents which do support his case, I find it helpful to know what they are.
and I will make good on that, my lord. I intend to show you a few of those. But it is also the case that one can hardly expect people who prepare fictitious documents, which have the hallmarks of being legally binding, to stamp them as sham, do not execute. One will have to test the circumstances, why people thought that it was right for them to do that which they did, what was the economic context, what they understood they were doing, what was the actual position, that's the most important thing, of this debt, which is supposed to be recycled from 2009 onwards. So I agree entirely, if I may say respectfully, that witness evidence, and I will come to indicate from whom this will come, will be very important. But just picking up, and I will also show some documents which will indicate that Mr. Vatistas' case meets the properly arguable case test. But you asked me, my lord, and I wish to give you an answer. Where does the judge say what he says? If I can ask, if I can direct your attention respectfully to page 67, second line, he says, the weight of the contemporaneous, forgive me, documentary material is inconsistent with and serves to undermine Mr. Vatistas' evidence. And then in the penultimate sentence, the assertion that there is no debt owing is a weak one. That is not the test. That is not the exercise that is to be conducted by the court, even if all of the evidence were documentary evidence and there was nothing else to be added, which of course cannot be the case because we're not at trial yet.
But it seems to be common ground that the judge did not go so far as to say that it was a case which was not properly arguable or which had no real prospect of success, because if the other side had thought that that's what he said, they wouldn't have needed their respondent's notice saying he should have gone further.
Your lordship has the point already. Yes. Can I then?
That's a separate point from what is the documentary evidence which you say supports your case, which you're going to come to.
Can I come to that right now, if I may, my lord? So, can the Batistas case be said to fall within the demonstrably unsupportable exception based on contemporaneous documents? One thing to say at the outset is that the documentary record at this very initial stage before disclosure comprises, this is the High Court bundle, about 1,500 pages. The Batistas and Salame witness statements comprise an additional 84 pages. And so recalling paragraph 22 of OCPABI, the more you deny, the more you establish that there is a tribal case here. The overall impression one gets is that the parties have joined issue on a multitude of factual points without knockout blows either way. And that may only suggest that the debate should proceed to trial. So let us go just a little deeper, showing ever so quickly a handful of documents. They all go to just one point, but it is a fundamental point. If Mr. Vatistas is right that the debt was sold to Abbottswood, was an amount exactly as Abbottswood paid, that is to say $4 million and not $40 million, then Betta's entire case collapses in its very premise. So I wish to show the court, if I may, 3 documents. May I ask that we turn up, please, supplemental bundle tab 6, page 38. This is an agreement between Sovereign, this was the exiting partner, defined here as the first party, Abbottswood, defined here as the second party and the assignee purchaser. It is countersigned, the court will see, by Tomini, if you turn to page 42, which is referred to as the debtor. Now, if I ask that we turn to page 39, we have a preamble. This refers to a debt. This is debt by Tomini to Sovereign. You will notice, my lord, my ladies, that the precise amount isn't specified in this agreement. It was subject to change and could not be determined precisely on a particular date because, as both sides accept, this reflected a running account between Tomini and Sovereign. And that amount could only be determined later. It was effectively an accounting figure. The important thing in this agreement is the amount that will actually be paid, as opposed to the amount that was owed. Can I draw attention first to clause 5, page 41? Forgive me, article 5. It says Abbottswood will pay Sovereign the sum of $3,945,000. And if we can glance back at page 40, article 3.3, this states that upon execution of this agreement and due payment of the price, that's the figure of $3,945,000, the debtor, which is Tomini, will automatically and by right cease to be indebted towards the first party, which is Sovereign, of any amount whatsoever. There are some stipulations which are not relevant for present purposes. Can we now look at Article 6.1? This says the debtor is hereby notified of the assignment of the debt by Sovereign to Abbottswood and of the reduction of the sovereign debt from its original amount of, again, US dollars blank, to US dollars 3,945,000, which becomes due to Abbottswood, the second party. And you will see that the very next clause, which is clause 6.2, provides that Tomini acknowledges and accepts the above undertakes to immediately register in its accounting said assignment so that it shows that the debtor, which is Tomini, owes Abbottswood an amount of 3,945,000. And that I say entirely parenthetically, my lord, my ladies, that registration in the accounting did not happen, and that is the source of many ills thereafter. Can I show the court, please, a second document? That is at tab 5, page 37 of the same bundle, supplemental. This is one further of the 4 agreements that gave effect to the 2009 deal, whereby Sovereign exits, Abbottswood, Mr Diab come in. This is agreement number 3, it is titled, between Abbottswood, Sovereign and Tomini, so 3 parties. May I draw attention to the penultimate paragraph, which provides that Sovereign, I quote, hereby declare that we cancelled all the debts of Tomini and we will not have any claims against Tomini in relation with the aforementioned debts. And that is exactly, my ladies, my lord, what Mr Vatistas says happened, i.e. the original sovereign debt was cancelled at about 90%, that is to say every penny above $3,945,000. The third document, and I promise this will be the last I would like to show you for now, is supplemental bundle tab 15 at page 99. This is a document that is now much further in time, dated November 2016, we will see on the top right-hand side. It is titled Loan Indebtedness Notification. And if you turn over to pages 100 and 101, you will see it is issued by Abbottswood, and it is acknowledged by Tomini. Returning now to page 99, may I direct attention to paragraphs 2, 3, and 5. These say that in 2009, Sovereign, I quote, assigned to Abbottswood all of its rights in respect of the debt. This is paragraph 2. And at paragraphs 3 and 5, they say that the amount due was $3,945,000. This is a document issued by Abbottswood to Tomini in November 2016. My lord, my ladies, there are reams of pages already in the High Court record. I can go on with documents of this nature and tenor, but it is entirely unnecessary. These contemporaneous documents, which are so together, lend support to Mr Vatistas' account that the predicate basis for Betta's claim that a debt of some $40 million was acquired from Sovereign in 2009 is absent. I say they lend support. They are not a knockout blow to Betta's case. The documents we have in the record are messy. The quality of drafting is
Variable.
Variable. I'm grateful, my lady. Less than optimal. The story is even messier. So what this tells us, and what this should have told the learned judge, is that this is an issue to proceed to trial. It cannot be dismissed on a summary basis without trial. Now, as to this, I expect that my learned friends will make 2 points in reply. It may be helpful for them to have our position stated up front, so I'll be very quick on this. The first of these points concerns a criminal investigation that Mr Vatistas asked the Romanian authorities to commence back in 2020 for embezzlement and forgery. The authorities have refused to do so repeatedly. May I ask that we turn to supplemental bundle tab 48, it's towards the end at page 324. We have here a letter dated the 29th of January this year from Tomini's, the respondents' solicitors. This contains 3 numbered paragraphs which outline the 3 decisions that have been made over time in Mr Vatistas's application for a criminal investigation to be commenced. This enumeration of itself, that's all we have, my ladies, my lord, tells us nothing about what conduct the Romanian authorities could have considered in an investigation, what conduct they may have considered as part of the decision not to commence an investigation. For example, we don't know what the statute bar is for criminal conduct. What is the period? We do not know whether what they have considered has anything to do with civil or indeed fiscal fraud. The charges here are forgery and embezzlement. These are technical categories of Romanian criminal law. I am unable to assist the court in how they match.
The reference at little paragraph 3 to the court issuing a final decision with reasons.
Yes.
Was that a document, don't take us if you don't need to, but is that a document that was available to everybody?
I believe so, we just don't have it in the record. So I was going with what we have.
Yes.
And I believe the reason that we have what we have, which is unopposed, the letter of the lawyers of Tomini is unopposed in its content, is because it's very difficult to understand from the reasons how they would map onto a civil claim about validity or invalidity. But I propose to say nothing further because it would be impermissible. At trial, naturally, once we have these decisions in their totality, with the benefit of expert evidence on Romanian law, if we come to consider the issue, the import of these decisions, if there be any, on the civil issues that are disputed in the English court, will be capable of being understood. For now, we cannot take a concluded view either way. All this to say, what we have from the Romanian authorities appears to be, on both sides, not a knockout blow to Mr Vatistas' case. Now, the second point I expect my learned friends will make is that it's not enough to say, I think there is a Dickensian metaphor, it's not enough to say some more evidence will turn up, one will have to articulate, they say, what evidence that will be. And as I say, we agree with that. It's a fair point. But the answer is abundantly clear to everyone in this room who has read the witness statements of Mr Vatistas and Mr Salome. Both contain extensive assertions about things that people do not normally document, such as economic dealings, pressure one side to the other, on one side's account, concerns about paying taxes to the rate of 16% and how that should be avoided, and so on and so forth. So there is extensive engagement already by way of assertion on both sides. We know, therefore, that there will be witness evidence from the Diab camp. I will not burden the court with names, you will see them in the documents, including, of course, Mr Diab himself. There will be evidence from the sovereign camp, Mr Imtiaz, and we have some documents already from the sovereign camp, but I didn't take the court to them. And we will have evidence from Mr Vatistas, of course. And we will have evidence from the former head of accounts at Tomini, Ms. Apostol. Mr Vatistas, I state clearly for the court, Mr Vatistas welcomes the opportunity for his evidence to be tested on cross-examination and welcomes the opportunity as a litigant to obtain evidence, witness evidence by others. My learned friends may be able to say the same for their side. So this evidence on any possible view and cross-examination on it as to matters of honesty, reliability, credibility will be extremely important in the circumstances of this case. The learned judge did not turn his mind to it at all. As to disclosure, one expects that there will be rich seams of internal exchanges within the Diab camp. As to the events in 2009, the exit of Sovereign and the genesis of the alleged debt, and also in 2014 to 2022, which is the period where various curious documents, which don't entirely make sense, on one view they don't make any sense at all, when put one next to the other, were created, and these include the so-called credit agreements on which Betta's claim relies. So there are a number of documents which are inconsistent with the story, and a number of documents which point one way, a number of documents point the other way, is the position. And there will be disclosure from the archives of those who created these documents, including two lawyers on the Diab camp. One of them is called Mr. Wetton. He's a struck-off solicitor, and Mr. McCann, perhaps. Now, I come to my fourth part, which is part of our appeal ground number 2. If I may, the learned judge, we respectfully submit, failed to consider, as part of the reliability requirement, the court's responsibility to ensure that its process not be abused. And I can address this briefly with 3 points, each of which can be short. The first point is that the decision where the court below has, as part of a multifactorial assessment, taken into account immaterial factors or omitted to take account of material factors is appealable. Our learned friends for Tomini expressly adopt this test at paragraph 29 of their skeleton, which is core bundle tab 14, page 172.
Do you want us to turn that up?
I was just giving it for your
Give
notes,
us
my
the
lady,
notes.
if I may. And I propose also to give you for your notes only at this stage, because this seems to be common ground, that the main authority for this test is 2 decisions of this court. The first is Stewart and Goldberg, legal authorities, tab 5, page 108, paragraph 82, which quotes and endorses an earlier decision called Aldi, legal authorities, tab 4, page 79, paragraph 16. Both sides refer to this authority. So I'm happy to leave this for your notes. Before I leave this first point, there is an asterisk, which I mentioned earlier. Although Tomini adopts the standard of review I've just described, it seems to vacillate between that standard and some very different standard, which it calls the standard of perversity. This is referred to at paragraph 5, subparagraph 2, and paragraph 57 of its skeleton, which is core bundle pages 161 and 180. We're not quite sure what their position is, but at any rate, we do not believe a standard of perversity is supported by authority or principle. Now, the second point concerns the court's power and indeed the duty to deploy what procedural means it has at its disposal to ensure that its process will not be abused. And I can take this as shortly as possible, my lord, my ladies, because I trust the propositions are so fundamental that there will be no contestation. The authorities certainly are, hence they are not part of the authorities bundle. So the duty of the court was expressed in clear terms by Lord Diplock in the Hunter case. The court defined abuse of process to include, I quote, bringing the administration of justice into disrepute among right-thinking people. Lord Diplock continued to say that the circumstances in which abuse of process can arise are very varied. And in the decision that we looked at, Abraj, the court considered that it is not a bar to a finding that there is an abuse of process, that there is no reported case on all fours with the present case. Now, what is the risk of abuse in the present case? The risk is that the court will not have before it the predicate material that would allow it to conclude that a knowing falsehood about fictitious debt was memorialized into two contracts which the court is asked by the claimant and also by the defendant to pronounce as valid and binding. I said this rather slowly because I wish to be extremely clear as to what the risk of abuse is. Now, if the court knows that these contracts are based on falsehoods, if it has the predicate material, would it pronounce them as valid and binding? Of course not. And does it make a difference if the two litigants before it, Betta and Tomini, ask the court not to consider evidence and allegations that could show, or on their face say they will show, these contracts to be based on falsehoods? Is the court bound by the procedural conduct of the litigants? Of course not. This court explained in Soleimani and Soleimani, which concerned an arbitral award giving effect to an illegal private agreement, that the English court, I quote, declines to enforce an illegal contract, not for the sake of the defendant, nor, if it comes to the point, for the sake of the plaintiff. The court is concerned to preserve the integrity of its process and to see that it is not abused, and the parties cannot override that concern by private agreement. Now, if there is a risk of abuse of process, which can be prevented through joining Mr Vatistas under CPR Rule 19.2, paragraph 2, then he should be joined. And in that regard, the questions to ask are these. Can Mr Vatistas' participation in the proceedings, in effect, I'm putting this in Abra's terms, as an interested party, can that participation place the relevant evidence and allegations before the court? Yes, is the answer. Can these evidence and allegations be placed before the court by any other party? No, is the answer. And so, we respectfully submit that in these circumstances, where the only possible source of this information to the court is a party who can come in by way of joinder, they, in practice, in effect, the wording of Rule 19.2, paragraph 2, which says may, has to be interpreted as must. I cannot shy away from that submission. That has to be the case. In certain circumstances, the court will be bound to conclude that it will be desirable to add a party. Will these circumstances be rare? One hopes they will be extremely rare indeed, but people, paper, debt, and money instruments for all sorts of reasons, money laundering, for example. I am not suggesting for a minute this was the case here, but some instruments do exist, and the court may be asked to pronounce on them.
Do you need to go as far as saying that may should be read as must? Isn't it sufficient for your purpose to say that if Rule 19.2 is engaged, so the gateway is open, and if it is desirable for the reasons you give, then somebody should be joined to enable all the issues to be ventilated, then the court can be expected to agree to the joinder unless there is some strong reason why it shouldn't.
I agree entirely, my lord. I say respectfully. But I thought the court might wish to put it to me as I was thinking about the case. Are you not saying that may in this case is must? And it seems to me that the right thing to do is to say that there are certain circumstances where the duty of the court compels it to exercise its discretion. And so, in effect, there will be some, as I said earlier, I hope very rare cases where the court will treat may as must. But it doesn't, legally speaking, my lord, my submission does not require the court to read may as must. My third and last point here is to consider the judgment below. Can I ask that we turn to it, please? Core bundle tab 6, page 67. The learned judge says this in paragraph 54. He says, second, even if the allegation were true, the allegation is the one in the preceding paragraph, as we saw, that there was no predicate debt owed in the first place. So even if the allegation were true, the fact that it is true would not per se render these proceedings an abuse of process. As I have already indicated, where the real complaint concerns the value of the defendant, the more natural place to look for a remedy is internally within the corporation or in the existing valuation proceedings in Romania. The proper way forward for Mr. Vatistas is to pursue one or both of these avenues. Now, we consider it our duty to read judgments of the court sympathetically rather than trying to parse words and trying to find fault. But we cannot see how the judge's approach can be right, with all respect. How is it possible to say, yes, I accept that the court will endorse in this hypothesis as legally valid that which is illegal and unenforceable and invalid, but that's not a concern. Because somebody else, namely Tomini itself, or a Romanian valuation judge, will see through the illegality that is the predicate of the judgment, will see through the sham contract and put an end to this, and will also put an end to the English court's judgment. How can it be an answer to guarding against the risk of abuse of process in the form of having the court rubber stamp, or the court's rubber stamping, for reasons good, bad, or indifferent, as I say, rubber stamping a sham instrument? How can it be an answer to guarding against that risk to say, well, after the risk has materialized, some other court or some other person will prevent it from spreading further? On this side of the aisle, and I mean this with all sympathetic consideration, we have been unable to answer these questions. And that, my lord, my ladies, takes me to the court might be pleased to hear is the last part of my opening submissions. It will be short. This concerns case management. We entirely agree that case management, that is to say, how will the new joinder participate in the proceedings, is an entirely proper part of the desirability inquiry. This is a point made emphatically in the Molavi case, which is in your supplemental legal authorities bundle at paragraph 45. It is not a decision that binds you in any way, but we respectfully commend it to the court because we respectfully submit that the emphasis is right. If I can ask the court to turn to the judgment in the present case, core bundle tab 6 again, paragraph, forgive me, page 65, paragraph 48-49. So paragraph 49 is over the next page, page 66. You will see the learned judge turned his mind to this issue briefly. In fairness to him, he placed no emphasis on this matter in his decision to dismiss the joinder of Mr. Vatistas. And in fairness to him as well, the parties had not and have not conferred regarding case management direction for the reason that there was opposition to Mr. Vatistas' joinder from the outset and entirely on grounds of principle. And so procedural modalities have not been explored. So these two paragraphs of the judgment here, 48 and 49, are lifted almost verbatim from Betta's skeleton in the High Court, my learned friend's skeleton, They are Betta's rhetorical questions rather than Betta's actual questions. They've never been asked of us. They are not difficult questions. Can I please suggest the answers to them? The learned judge asks, if we were to serve a statement of case, if he were to serve a statement of case, Mr. Vatistas, would it be an alternative defense for the particulars of claim, or would it rather engage with the defendant's defense? Answer, an alternative defense it will be, as commonly happens in cases with multiple defendants. The learned judge says, this is now paragraph 49 over the page, if Mr. Vatistas were to provide a statement of case, to put forward a positive case, how would the parties deal with that evidentially and prepare for trial? Answer, in the same way as in any other case with multiple defendants. Goes on to say, by extension, if Mr. Vatistas' case does not fit with the defendant's case, is the defendant expected to meet both the claimant's case and Mr. Vatistas' case? Well, the answer is that this case will be simpler than the case where you have claimant C suing defendant 1, defendant 2, and defendant 3, and the three defendants argue among themselves if they have separate legal duties and obligations, who is responsible and to what extent, as to the claim of the claimant. This case will be simpler because Tomini hasn't asserted any defense at all to Betta's claims. It has largely admitted them. It has admitted the first claim, which is the claim I was discussing today. And as to the other three claims, its position is very simple to address.
How much do you say we need to go into these matters in order to decide whether Mr. Batistas should be joined? For example, if he is joined, he will at least need to produce a statement of case saying what his is. Thereafter, questions such as which party should give disclosure and going to what issues might be better regarded as for case management in the commercial court rather than for us to try and predict now. I have in mind, for example, that Tomini might want to say, why should we be required to give a lot of disclosure on a claim which actually we admit? Do you say we as the Court of Appeal need to decide those sorts of questions, or whether if you get over the hurdle of being allowed to join the party, they are for commercial court to decide at some future stage?
I say they're entirely the opposite of being matters for the Court of Appeal. I was suggesting that they are quite straightforward cases of, issues of case management, which can be resolved between the parties. Nothing really new under the sun, and these will be matters for the High Court in due course for case management direction. That is all I was wishing to indicate, my lord, that these questions are not insuperable, and I was pointing out, in fairness to the judgment below, that the judge himself did not regard them as insuperable. He was just saying there are questions that arise, need to be resolved, but the parties have not yet conferred. And that is the position. I wish to reiterate, however, that Mr. Vatistas will also be potentially liable for costs in the normal way if his case fails. There is no dispute that a party that joins pursuant to CPR 19.2 paragraph 2 can be held liable for costs in appropriate circumstances. No one is suggesting a free ride, as I mentioned earlier.
Now, can I ask you something related to that? Because one consequence of Mr. Batistas being joined is that this litigation is going to be more complicated and more expensive than if he is not joined, regardless of what particular case management decisions may be made. At a stage where you say we can't decide and shouldn't decide whether his case is right, it's only properly arguable. One possibility might be that as a condition of being joined, he should be required to make some payment into court by way of security for costs if it turns out that his case is wrong, and he has, in effect, wrongly put the other parties to a great deal of increased costs. What would you say about that?
I would respectfully submit, my lord, that that would not be the right answer for two reasons. At the early stage, one applies the Okpabi test. Now, if Mr Vatistas' case clears the Okpabi test, he is entitled to join the proceedings. He is an ordinary litigant. The second point is that if there is a further circumstance, not his joining the fray of litigation, but a further circumstance down the line, which would require, for example, security for costs, that would be an interim measure. What would have to be shown is that shown by the applicant for the interim measure would
Well,
be.
if he's joined as a defendant, which is what you're asking for, there won't be any scope for an order for security for costs, because you can't get security for costs against the defendant.
Yes, I entirely take.
So it's now or never, so far as that's concerned.
Or it will be an interim measure of some other nature. I entirely see now the point that your lordship is putting to me, and I will also need to reflect a little on it. We've never seen it on the decided cases as a possibility, and it's never been suggested in this case, which is why I haven't considered it.
Right, well, as you've just discovered, it's something that is at least going through my mind, so if you want to reflect on that and come back to it at some later stage of reply, then please do.
And I'm grateful for that indication, my lord. Unless I can help the court any further, that would conclude.
No, thank you very much. That's most helpful. Yes.
My ladies, my lord, I'm going to begin my submissions with a series of propositions.
Sorry, sir, can you move your microphone?
Is this one? I'm sorry, my ladies, my lord. Can you hear me right now?
Yeah, it's coming onto the screen.
I'm grateful. Yes, as I was saying, I'm going to begin my submissions with some propositions, which I say are all uncontroversial. But of course, my lord and my ladies might disagree, and if you do disagree, I'll know where I have work to do. I'm not trying to cheat by producing another document. I've written them down just so that your fingers might be spared whether you type or write. I don't know whether you want me to pass them up, otherwise I'll just...
Yes, please. No objection, is there? Have you got a copy?
Of course, yes. It will be exactly as I speak. I tried to get them onto a single page, as you'll see. There's one line over because I didn't want
None whatsoever.
I didn't want to play with font size or margins. So,
No,
so
grateful.
they are 12 point and regulation margins. And
If you make it too small, you may as well not bother.
exactly. Well, that's
Quite. Thank you.
so I'm not just going to read them aloud. I'll add a few observations to them, but I didn't want to take liberties by including those observations in this document. So the first proposition is that the order under appeal is the result of a discretionary case management decision. So, the second proposition is the decision in question turned on a multifactorial that the value-to judgment of the type from the appellate tribunal should be slow to interfering. 3 and 4 go together. We say that the judge correctly identified the two applicable tests. The fifth proposition is that in applying those tests, the judge must be presumed to have taken into account all the relevant material before him, if authority were needed for that proposition. It comes from the well-known statement of Lord Hoffmann and Biogen. Sixth, we do not need to rely on that presumption of taking into account all relevant factors, because the judge explicitly took into account the 4 factors relied on by the appellant under ground 2. And a notable feature of my friend Mr Patroclus' submissions was that he didn't press ground 2 as pleaded or as developed in his skeleton. For reasons I'll explain, he can't, because the primary basis of that challenge is the judge failed to take into account 4 factors. The judge took them all into account, and then he's into a complaint about weight, which also goes nowhere for reasons I'll seek to show. On weight, Proposition 7, an appellate tribunal can only overturn an evaluative judgment on the basis that the judge gave inappropriate weight to particular factual factors if it is satisfied that the weight given was weight no reasonable judge could have given to the relevant factors. And that's what we mean by perverse. That's consistent with Sprint Room, a decision of this court that I will show you in due course. If a judge either takes into account an irrelevant factor or excludes from consideration a relevant factor, or gives weight to a factor that no reasonable judge would, that judgment, evaluative judgment, is perverse in the relevant sense. But it's also just, it's wrong and therefore open to challenge on the appeal. That's what matters. So it's not as though I'm trying to import some different test. The test is as formulated in Sprint Room, and Proposition 7 reflects that. 8, this is almost common ground, where an applicant is seeking to be joined or to intervene to put forward a particular case. An essential precondition is that the case it has a real prospect of success. I'll refer to that throughout as the merits threshold. Where Mr. Patroclus fell into error is in suggesting that clearing the merits threshold is dispositive. It obviously isn't. So if you're seeking to be joined or to intervene to run a case, it is necessary but not sufficient to show that your case has a real prospect of success. If your case has a real prospect of success, then there is the evaluative judgment of whether, as regards intervention, it is in the interest of justice for you to be permitted to intervene, and as regards joinder, whether it's desirable to join you. And then there's the discretion. So it's a 3-stage inquiry, and Mr. Patroclus quite wrongly suggests that if you clear the first hurdle, you're home and hosed, and you are not. 9th, of course, this goes without saying, it's common ground, the burdens on the applicant to satisfy the merits threshold. I'll come back to the importance of that, in particular in relation to a point which I should make clear now, was not run below, is not in the skeleton, and is not in the grounds. And that's Mr. Patroclus's point that new evidence might emerge later, the McCallberg point. It was not run, and Mr. Patroclus conflates what Lord Hamblin says in Parby is the reasonable belief or reasonable grounds for the belief that disclosure will bring to light new material that alters the assessment of real prospect of success. The focus is only on disclosure, i.e. documents. My learned friend's submissions focused on witnesses that might come to court. And that's not right. That's not what Parby says at all. Saying, I hope that witnesses might come to court and support my case is undisguised McCallberism. Of course, it's Mr. Vatistas' application. If Mr. Vatistas thought there were witnesses who'd help his case, he could have filed statements from them. His counsel to say, oh, Sovereign's witnesses will help him, it is not something that this court should attach any weight to. It's also not a point that was run below. And I'll return to the idea that more material might come out in disclosure. But the short answer to it, apart from it's not open to them, is Mr. Patroclus rightly conceded that for that point to have any legs, there would need to be evidence as to the nature of the material that would come to light, and there is none. He said in a lovely flourish that there would be a rich sheen of internal documents from 2009 from Mr Diab's camp. Well, that's not in evidence. And also, Mr Vatistas was in the camp in 2009. One of the really striking features of this case. So Mr Vatistas, although on a quick reading of his documents, one would be forgiven for overlooking this point, but Mr Vatistas was intimately involved in the alleged fraudulent scheme. So it's not as though he was out of the tent and he really wants to know what documents were in the tent. He was in the tent. He's produced a wide array of material. And so even if he had said in evidence that there might be more documents to come, and he didn't say that, there wouldn't be reasonable grounds for the court to believe that he was right. And I'm sorry, I'm slightly moving away from my propositions. I promise to return to them in a moment, but just to my Lord Justice Mayle's point, of course, one of the points my Lord Justice Mayle's made, of course, one wouldn't expect there to be documents, formal documents, evidencing the fraud in the sense of, dear X, I'm going to produce this sham now, hope you agree. But one would expect at the very least a documentary footprint, a documentary trace in WhatsApp messages or text messages or emails, contemporaneous notes, diary entries, as in some hints at the scheme, because even the most meticulous fraudster tends to leave some documentary mark, and there is none in this case, and the judge so held. Back to my propositions in the 10th one, which is that in a case such as the present one, mere assertion cannot of itself satisfy the merits threshold. That is completely consistent with Harvey and also the judgment of my Lady Justice Asplin in elite property. And it's also just a matter of common sense, because in a commercial case, a document-heavy case, where there is a documentary footprint for so many different things, just saying, here's my assertion, I know all the documents that are before the court go against it and none support it, but please may I have a trial, is not good enough. In contrast, if there's a road traffic accident and it's just one person's word against another, mere assertion might well be enough to justify a trial, or if interventional joinder were the relevant question, to justify those things, which is why Proposition 10 is framed as, in a case such as the present one, a mere assertion is not sufficient. And then 11th, the judge's findings, I needn't repeat them orally, that they are there set out, and will return to the relevant paragraph of the judgment. As to the weakness of Mr Vatistas' case and the state of the documentary material, first, I'm not challenged on this appeal, and second, I'm not open to challenge on this appeal. This appeal is categorically not brought on the basis that the judge's finding that Mr Vatistas just had assertion and assertion alone was wrong, or that his finding that the weight of documentary evidence was against Mr Vatistas was wrong, or that the judge's finding that the documents there were no clear documents supporting Mr Vatistas' case was wrong. So
it is slightly by the back door, and I'm not in any way casting any aspersions, but it is said, of course, that there shouldn't have been a mini trial.
yes,
And accordingly, those were the outcomes of what is said to be the mini trial. So it is.
by that, my Lady Justice Asplin makes a perfectly fair point, which I will come on to deal with. So if you agreed that a mini trial was conducted and it wasn't, what the judge did was exactly what the authorities say is permissible. I don't need to say he needed to do it. It was just a permissible approach to an introductory application to look at the documentary material that was put before him and ask the question, is there any support for what Mr Vatistas asserts? Does the weight of evidence go against him? Those are appropriate questions to ask in this introductory stage, precisely because assertion isn't enough. And the respondent to this kind of application, as the highest authority makes clear, is entitled to put before the court material which contradicts witness evidence or shows it to be unsupportable. And that's precisely what the respondent did in this case. To take an example, the 2015 credit agreement, Mr Vatistas said, professed ignorance of having signed it. And so Tomini said, here's the evidence of you having signed it. It's an obviously permissible thing for Tomini to do, which was an example of the evidence that the judge referred to in saying the weight of the evidence is inconsistent with Mr Vatistas' case. So Lady Asplin is right, that if the mini-trial challenge works, I no longer have the benefit of the findings. But if the mini-trial challenge works, then the whole exercise of discretion and value to judgment were arguably unsound. The consequence of that wouldn't be this appeal being allowed and Mr Vatistas joined, it would have to be remission. Because if you say mini-trial impermissible, this court doesn't have before it all the material, the argument doesn't have the time to properly consider the matter afresh and exercise its discretion in place of the judges. Save only if this court accepted the submission that if there's a real prospect of showing abuse, and that real prospect is made out in this case, if the court found that, then joinder or intervention almost automatically follow. Then only on that basis would anything other than remission be appropriate. But I say that entire hypothetical basis would be beset with flaws. So if the mini-trial complaint works, it's remission. The mini-trial complaint doesn't work as a matter of authority and as a matter of a fair analysis of what the judge did. And if the mini-trial complaint falls away, as I say it must, then those findings, this is the 13th proposition, are baked into this appeal. So and I say more than that, they contextualise everything. And they overarch everything. The judge found Mr Vatistas' case was weak. He made the findings he did about the documents. And so, just pausing there, when there's a weak case, unsupported by any documents and contradicted by the weight of documents, it's not a promising start for an appellant seeking to say that the judge was sprinter of wrong in refusing joinder or addition. The 14th proposition, the last over the page, is that in order to succeed on this appeal, in the sense of getting joinder or intervention from my ladies and my lord, Mr Vatistas would really have to establish that joinder or intervention was mandated in the circumstances, and that is really what Mr Patroclus was saying when he said it's a case of must. And then I'm not trying to stick him with that. Of course, my Lord Justice Miles is right. He doesn't need to go as far as must. He can just say almost always would, or absent exceptional circumstances would. But I say it would be quite wrong for this court to set down as a principle that if a third party scrapes over the real prospect of success threshold with an abuse allegation, then joinder almost always or absent exceptional circumstances is the appropriate response. That would be far too much. It would, I'm not suggesting that Mr Vatistas is as unscrupulous as this, but it would be a charter for members. Because if you could get something over the real prospect hurdle, then suddenly you have a seat at the litigation table. With consequences that go well beyond to a point my Lord Justice Mayles raised about the position of Tomini. Tomini does not want to run this defence. Tomini is a company. Companies act through their directors or sometimes through a majority of their shareholders. And so if Mr Vatistas were permitted to join or intervene to run a different defence from the defence that Tomini wants to run, a shadow defence, it's a kind of derivative defence, but of course derivative defences are alien to English law and any system of law that I know of. Would it be, of course, putting Tomini and Betta to more costs? Some of those costs wouldn't be recoverable. There's the issue of security and so on. But more fundamentally, it would be interfering with Tomini's corporate autonomy. It would be dragging things out. and there's clear authority that of this court that a company should be allowed to run the defence that it sees fit. And you need something more. That's the proposition which there's direct authority. And I am adding, a shareholder must need something more than a barely arguable allegation of abuse to intervene and disturb that principle of corporate autonomy.
But your client doesn't want to run a defence at all. It wants to admit the claim, at least so far as the principal debt is concerned. I know there are other bits and pieces in the case. And so one can't help thinking, well, what is all this litigation about? Why is there a claim for a declaration which the defendant admits? I mean, if I have a claim against you and you admit it, we don't generally go to court to get a declaration about it. You just pay me the money.
Yes, but
so what's going on? That's
of course,
what
there were
Mr Vatistas is saying.
But that's partly what saying. That was obviously what he was saying loud and clear to the judge below, and the judge, contrary to what Mr Batistas now submits, did take it into account, explicitly took it into account, weighed it in the balance, as in weighed in the balance the risk that these proceedings are abusive, and nevertheless decided as he did. And so, the first part of my answer to my Lord Justice Nails is it isn't for this court to inquire into the purpose underlying the proceedings, precisely because the judge did so, and the door isn't open to this court going behind the judge's analysis unless this court is satisfied that he failed to have regard to a relevant factor, or gave a relevant factor weight that no reasonable judge would have given it.
All right, well, you'll show us in due course where the judge addresses the question I asked you.
I will, of course. Well, and to be very clear, my lord, he addresses the risk of abuse at a number of places. He doesn't address head on the question of what on earth are these proceedings for. The second answer to my lord's question is, of course, the proceedings go well beyond a claim just for this debt. And a notable feature of Mr Vatistas's original application was that he attacked not only the admission of this debt as abusive, but other debts as shams or non-existent, and the admission of those debts as abusive too. And then, as I'll show you, he had to give up that and say, no, I had no basis for that. So he is demonstrably a man who shoots first and then looks for evidence later. And that is another factor that the judge was very much alive to below, because it was brought to his attention.
But going back to my Lord Justice Nails's original question, which you now accept the judge didn't deal with, are you saying this court is not entitled to ask what on earth is the motivation for this litigation, which seems rather opaque to
Well,
us?
so, my lady, first of all, if I might just finish my propositions, although I am anxious to resolve your ladyship's and my Lord Justice Nail's questions. The devil is in the detail on what the judge did and didn't consider. So I was not saying the judge didn't consider that question at all. I'm saying there isn't a part of the judgment that says, here is that question posed and here is my answer to it. So my answer to the Lord Justice Nails was to the effect that in weighing the risk of abuse, the judge implicitly took into account that question. And then as regards my Lady Justice King's question, first of all, I am constrained by the material that's before the court. I'm not about to give evidence. Second, of course, subject to that, I'm anxious to assist this court in any way I can. But third, with the greatest of respect, my starting point is this is not a rehearing. This is a challenge that the highest authority makes clear has to be on a narrow basis. And so as interested as this panel might be in what on earth is going on here, my primary answer with respect and deference is it's not
None of our business.
It's not your business, unless the door is open. But might I would like to come back to that question and think carefully about what I'm able to say on the material before this court and the material that was before the court below, which I can obviously do over the short adjournment. So I hope that commends itself to my ladies and my lords. I'd finish the propositions on the page, and I just had two to add in the light of Mr Patroklous's submissions. The first is, it does not follow that if the instruments that Mr Vatistas alleges are shams, these proceedings are abusive. And that's the proposition. And to explain it, elaborate on it. And when Mr Patroklos was making submission for the respondent's notice, my Lord Justice Nails said, well, I thought that is exactly your case, is that these proceedings are being brought for an improper purpose and that Tomini's director is acting other than in Tomini's best interests. Mr Patroklos says, well, that doesn't need to be part of our case, so it's context. it does absolutely need to be part of his case in order for it to be a case of an abusive process. Because even if the directors of Tomini knew that the instruments were shams, if, for example, they thought that Betta would succeed in proving its claim, then admitting the claim would not be improper and would not be a breach of duty. So imagine they'd received advice. All the evidence points in favour of these instruments being genuine, so the claim is going to succeed. They could make a perfectly valid commercial decision to admit a claim that they believe to be bad. That's just one example of how sham alone doesn't equate to abuse of this court's process. And actually, I said I had a second proposition to add. I've really already made it, which is that just clearing the merits threshold isn't enough. So, as to the proposed structure of my remaining submissions, I'll first deal with some background matters. I'll then deal second with the approach to questions of joinder and intervention. Third, some overarching principles. Fourth, some observations on evaluative judgments. Fifth, the supposed prospect of further documentary material coming to light, to which I've already alluded. I'll then deal with the grounds of appeal in turn. And then my learned junior, Ms. Thompson, will address the respondent's notice. 2 hours gives us combined till just before 10 to 3. So I plan to sit down just before 2:30 to avoid Ms. Thompson having to make me, just so that.
Well, we're rising.
And of course, no. I was including the.
No. What I meant, we are aiming to rise shortly after 3:45.
Oh yes, my leg. That's all baked in. So
Good.
Mr. Vatistas, sorry, I ought to have dealt with timing earlier then to allay any concerns. Mr. Vatistas and I agreed that we would divide our time evenly between us, with his time divided between his opening and his reply. So we would have 2 hours each. And when I say we, I'm using we to embrace Ms. Thompson. Mr. Reid is content with only 20 minutes.
Yes.
I heard my lady loud and clear say that the court needs to rise before if there's a few minutes extra, so be it. It will be for the benefit of Mr. Patroclus's reply submissions. Because 2 hours for me takes us, Stephen Thompson, to 2:50 p.m. And so that's why I'm saying I shall endeavour to sit down by 2:30. I'll probably spend more time explaining timings than I
everyone
needed
seems
to,
extremely crisp and organised so far, so I'm relaxed for mine.
I'm very grateful. So
So number one, background.
those points out of the way, exactly. On to background. First, the judge's findings as to Mr. Vatistas' case, at paragraph 53 of the judgment, which you've already been shown and looked at some length. Of course, by the respondent's notice, we say that the judge did not go far enough in merely saying that the case that no debt was owing by Tomini was weak. That conclusion, as to the weakness of the case, was an evaluative judgment. But the conclusions on which it was based, as to the state of the documents, were factual findings. So the judge made a factual finding that the weight of the contemporaneous documented material is inconsistent with and serves to undermine Mr. Vatistas' case. And that's a finding he made on all the material available to him, as opposed to a cherry-picked selection of material here. A real danger in Ms. Patroklos just showing a couple of documents to my ladies and my lord is that, of course, context is everything. One needs to view all the documents, not only in the context of the documents around them, but also the witness evidence that was before the court.
No island hopping.
No island hopping, even on an interlocutory appeal, and we'll deal with such documents as we have time to deal with. But one point that was striking was my Lord Justice Mail will show us the documents that support Mr Vatistas' case, and they don't provide robust support for Mr Vatistas' case of a fraudulent scheme. They're straws in the wind at best, and so they're completely consistent with what the judge said, which was no clear contemporaneous documentary support, and the weight of the documentary evidence is inconsistent with and tends to undermine Mr Vatistas' case.
Can I just say that the question I asked you, which you're going to think about, i.e. what is this litigation really about,
Yes.
what's its purpose, may also have a bearing on the merits threshold, because if we were to accept the judge's view that looking at the documents, the case looks weak, but on the other hand, this litigation doesn't seem to make much sense either, and that might cause us to think maybe there's a bit more in this than we first thought.
Well, I quite see that, which is why I'm so anxious to give an answer to my Lord's question on material that I am entitled to refer to, rather than
Yes.
give you an answer without having carefully
No, that's
considered
fine. I
it.
just wanted you to see that it may have that possible relevance as well.
My Lord, I quite see that, but I repeat that the door's only open to that if this court considers that there was something unsound in the judge's approach. This isn't just, would we have made a different decision? The question is, it was first of all, were the findings of fact, well, the findings of fact aren't challenged, so we're stuck with the findings of fact. Then, is the evaluative judgment sprint room wrong? The way that you get to is the evaluative judgment sprint room wrong is either by saying he failed to take into account something that he should have taken into account, or he took into account something irrelevant, or really exceptionally, he gave inappropriate weight to a particular factor. And unless the door to my Lord Justice Mail's inquiry is only opened by a prior conclusion that the judge was sprint room wrong in the evaluative judgments that he reached as regards joinder and intervention. And potentially one way that door could be opened, although of course I say it wouldn't be opened by this, would be if my Lord Justice Mail said, well, I'm so puzzled by the purpose of these proceedings that the judge must have given inappropriately little weight to the puzzlement factor, and therefore his evaluative judgment was sprint room wrong. But unless you reason in that way, we just don't get into the question of what is the puzzlement factor and what's the explanation for it. And my Lord, I hope that is an orthodox analysis and consistent with the authority of this court on the approach to evaluative judgments. Precisely because almost every judge approaches interlocutory questions, discretionary questions, evaluative judgment questions in different ways. And it's not the function of this court to enable an unsuccessful applicant just to have another go. And a further point, my Lord, is, of course, I don't have all the material that was before the judge below, which is why I need to be so careful in the answer that I give to my Lord in due course. It's not procedurally fair to pose to me a question that all the material relevant to isn't in the bundle that we haven't prepared to meet. Because it's not as if the appeal was made on the basis that, I'm calling it the puzzlement factor as a shorthand, I hope everyone understands what I mean by that. But the appeal is categorically not being brought on the basis that it's very strange that the purpose of these proceedings hasn't been properly explained, and the judge failed to take that into account or failed to give that appropriate weight. If that had been the challenge, we would have prepared differently to meet the appeal. Different material would have been before the court. And so it's a further, all of these procedural safeguards and the principles governing how narrowly a challenge to an evaluative judgment may be permitted exist for very good reasons. And I say all that with great diffidence because, of course, my natural instinct is to try to help the court with answers to its questions. But equally need to defend those procedural safeguards and the position of my client.
Okay.
You come to this court to defend an appeal based on the grounds of appeal as advanced. My lord, the judge did look at what he described as a suite of documents. The 2009 deal was highly documented, and this is really just repetition or emphasis. But as regards the judge's factual findings on the documents, I don't need to persuade you that they were right. I don't even need to persuade you that they were open to him, because they're not under challenge, save for by means of the mini trial challenge, which I say is inapt. Stepping back, the judge's factual findings as to the documents and evaluative judgment as to the weakness of Mr Vatistas' case are reinforced with even a brief consideration of the inherent probabilities. Mr Batistas says, no, what happened wasn't an assignment of a highly distressed debt at 6 cents in the dollar, which of course is inherently plausible, it makes commercial sense. Just for your relationships and lordships to note, Mr Vatistas' evidence as to how distressed the debt was at the time of the assignment is at paragraphs 13 to 14 of his first witness statement, supplemental bundle 233. The price of scrap metal had collapsed. Tomini had a huge liability. Its main supplier was determined to cut its losses. Tomini was on the brink of bankruptcy, so it was as distressed as really a debt gets. So 6 cents in the dollar makes commercial sense as inherently probable. And Mr Vatistas' case is assignment at face value. In other words, you purchase a debt, a highly distressed debt, at 100 cents in the dollar, and immediately crystallise a substantial loss once you account for credit risk. And then Mr Patroclus said to my Lord Justice Mills, he doesn't need to get jointer intervention, have a real prospect of demonstrating the collateral agreement that he says was made about the inherently improbable assignment not being enforced. So that's just a flavour of the position on inherent probabilities as they lay before his lordship. Moving on, the second background matter I can deal with briefly, but it is important to deal with, notwithstanding what my learned friend Mr Patroclus said about the criminal proceedings in Romania. They are not a silver bullet. I'm not suggesting that because the criminal proceedings have been thrown out, therefore this appeal must be dismissed. That would obviously not be a tenable submission. It is contextually important to explain to this court what Mr Vatistas said and then chose not to say about the criminal proceedings below. Mr Vatistas below relied on the fact that he had made a criminal complaint in support of his application for joinder or intervention. And that is paragraph 37 of his witness statement at supplemental bundle 241. What he failed to say, either to the court or to Tomini, was that the criminal complaint was dismissed, and then he challenged its dismissal, and that challenge was also dismissed. And all of that is clear on the face of the agreed summary that Mr Patroclus already has taken you to 324 of the supplemental bundle. So those events post-dated Mr Vatistas' evidence. He didn't bring them to the court's attention. He didn't bring them to Tomini's attention. Tomini discovered them a very short time before the hearing through checking the online portal for criminal proceedings in Romania, by which point Mr Vatistas had filed his reply evidence, also not mentioning that the criminal proceedings had been dismissed and his challenge to them had been dismissed. So he was far from candid with the court about the state of the Romanian criminal proceedings, and which is another factor that came into the judge's assessment of his case as a weak one, because there are assertions and assertions. This was an assertion by a man who had been far from candid with the court. I've already mentioned his evidence in relation to the 2015 credit agreement, which needed to be corrected by Tomini. But I'm going to take this briefly. It was an important plank of Mr Vatistas' application as presented to his lordship that there were these extant criminal proceedings, and that was a plank that had fallen away before he moved the application. The criminal proceedings were a dead letter then, and are an even more dead letter now. And on the point of what I may permissibly address this court on, the reason why we sent that letter to the other side was to avoid having to make a Loudon Marshall application to put before the court material in relation to the criminal proceedings, to the extent that the court might have considered it appropriate to have regard to such material. And all I will say was I was disquieted by speculative submissions that Mr Patroclus made about what may or may not have happened in the criminal proceedings. And certainly his client knows what happened in the criminal proceedings. So I would invite the court just to disregard any speculation about why the criminal proceedings were dismissed. They were dismissed again. The challenge to them was dismissed at judicial level. So there were two prosecutorial decisions, and then a judge reviewed the prosecutorial decision not to prosecute.
You said the judge took that into account when deciding that the case was weak, but it's not in paragraph 53, and I don't know whether I've missed it, whether there's discussion of the criminal proceedings anywhere in the judgment.
My lady, I was not saying the explicitly, but I was saying something that came into the balance in his assessment of the weakness of the case, because it was a material that it was a point that was front and centre in the submissions.
But he doesn't record it, I don't think.
He doesn't record it. No. I was not trying to suggest that he'd recorded it. I was saying.
No, I was just wondering whether I was mistaken about that. That's all.
The fault is mine, my lady, in how I expressed it, because it's part of the biogen point. So the judge had all the material. The judge reached his conclusion, and it's surrounded by a penumbra of other material to which he would have had regard, but may not have explicitly mentioned in his judgments. And so that was really why I was dealing with the position of the criminal complaint. And I've already made the shoots first and worries about evidence later point, but just for your note, that is made good by paragraph 9 of our skeleton call 163. And all the references there. So that sets out Mr Vatistas originally crying foul in relation to a wider set of debts, and then saying, no, I didn't have a basis. So the judge found his case was weak and based on mere assertion, and the judge also knew by the time of the hearing that Mr Vatistas was a man who made assertions without a proper basis for doing so. And then the final background matter, just briefly, on my Lord Justice Mail's reasons for granting permission to appeal, of course recognise that those are rarely, if ever, foremost in your minds in considering the issues on appeal once permission was granted. But I did just want to deal with one point. It's at tab 11, page 125 of the full bundle.
Which document?
Oh, so this is my Lord Justice Mail's
Oh, right, his order.
and reasons. Yes.
Sorry, just have his order separately. Thank you.
So my Lord Justice Mail said the appeal's argument for real prospect of success. In particular, the key point appears to be whether, as the applicant asserts, these proceedings are being used collusively by the claimant and defendant as part of a fraudulent scheme. And then my Lord will just knows when to say, if so, it's arguable, only arguable, I note, that they should be permitted to intervene. And then, on the other hand, the judge regarded the case as weak and his decision involved an exercise of discretion, but overall the issue merits consideration by the Court of Appeal. My main reason for going there is to say the key point below was whether Mr Vatistas' case of abuse was sufficiently strong to be a powerful factor in favour of joinder or intervention in the eyes of the judge below. And the judge held, one, it's weak, and then made the findings he did about the documents. And then two, here are all the other reasons why in the evaluative exercise I have to perform, I decide not to join or intervene. I explained it was a three-stage test, both in relation to joinder and in relation to intervention. The judge didn't get to the third stage. He didn't get to the exercise of discretion because, as I'll show you in the judgment, he held it wasn't in the interest of justice to permit intervention, and he held that neither of the limbs of 19.2 were satisfied. So those are threshold evaluative judgments before one gets to discretion, and you have the point. We say the judge should have held that Mr Vatistas didn't clear the first hurdle, but he, on the judge's evaluative judgment, failed to clear the second hurdle of interest of justice or desirability.
Well, while we're on this order, of course, the reasons for giving permission are only ever a provisional view, but these reasons do at least make clear that in giving permission, I thought that the key point was whether these proceedings are being used collusively as part of a fraudulent scheme.
Yes.
And the parties were therefore on notice that, at any rate, one member of the court thought that was the key point, and I would have thought that the court is therefore entitled to proceed on the basis that it will have put before it the material which bears on that question. And I say that because from time to time you've hinted that there is material which might be relevant to that, which is not before us.
Well, my Lord, on the notice point, I have been warned and know this court to have given other warnings about placing too much, if any, real weight on the reasons given in a document in order granting permission to appeal. That the reasons given don't alter the scope of the appeal. They can just permit an appeal on grounds or not. And I want to be clear, I'm not trying to do an advocate's trick of hinting material that I know to be there. I've fairly said I need to consider it over the short adjournment, and I hope fairly made the point that we prepared to meet the appeal as advanced. There's obviously a great deal more material below than there is before this court, and if we sought to put all the material below before this court would have deprecated that.
Yes, but I mean, I didn't make it up. It was there right up front in the appellant's permission to appeal skeleton.
Well, my lord, what was in the appellant's permission to appeal skeleton was that these documents were an abuse, these proceedings were an abuse, because we knew the debt not to be owed, and I repeat, were acting in such a way and with such a state of mind as to make our admission of the debt abusive.
Because both Betta and Tomini are under the control of a single individual whose interests would be served by the court issuing an order affirming that Tomini is massively indebted to Betta, when in reality no such debt exists. And essentially what the appellants are saying is that Mr Diab's right hand is suing his left hand.
Well, my lord, that point I'm coming on to in relation to ground 2, but that point was squarely addressed by the judge below at a number of points in his judgment, the ultimate control allegation. So I'll need to go to that. And of course, anything that's in the grounds I'm fully ready to deal with. things out with the grounds. Actually, my reason for taking you to this, my lord, was to say, I can understand why, as a shorthand, my lord said the key point appears to be this. But of course, the key point in this, or the key point or points in this appeal, are governed by what grounds are put forward and what, as a matter of authority, it is permissible for this court to do in relation to an evaluative judgment. So saying, oh, I rather think that these proceedings are being conducted collusively would not be a sufficient basis for allowing this appeal. Saying, my Lord Justice Mail saying, if I had been the judge, I would have allowed joinder intervention is not a sufficient basis for allowing this appeal. What would be necessary would be, and any reasonable judge in that position would have also concluded. And that's a vitally important distinction. You just don't approach this kind of appeal by saying, what would I have decided? Maybe that's a useful hypothetical to pose at the very start before saying, and is that something that every reasonable judge would have decided?
Mr. Portfis, I think you can be assured that we don't think that this is any kind of rehearing, or that we're not going to flip the dice and say, well, I wouldn't have done that.
No. Well, and I just...
I think we've all read Piglaska.
Sorry?
I think we've all read Piglaska.
Exactly. I'm comforted by that, and of course I took it as read, but these questions still raise understandable alarm, because just saying, well, what about that factor? The first answer is not a factor in the grounds, and the second answer is, well, come back to my propositions. Presuming the judge's favour that he took everything relevant into account, irrespective of whether it's explicitly alluded to in the judgment. And then on weight, it needs to be that factor of such compelling force that it made the decision under challenge perverse in the Springer sense. So I won't keep labouring the point, but...
We have your point.
On joinder and intervention, the tests before his lordship were common ground, which is unsurprising given the state of the authorities and given that the test for joinder is prescribed by 19.2. 19.2 has the overarching requirement of joinder being desirable, but there are two ways into that conclusion of desirability, which are, first, that joinder would enable the court to resolve all the matters in dispute in the proceedings, that's sub A, or sub B, that there is an issue involving a new party and an existing party which is connected to the matters in dispute in the proceedings. And my learned friend Mr Vatistas was quite right in response to my Lord Justice Mail's question. Matters in dispute in the proceedings is interpreted in the wider way that was interpreted by this court in Pablo Star. Now, if either precondition, lim A or lim B, is satisfied, then there is the evaluative judgment of is it desirable. So you need one of those preconditions, and then there's the evaluative judgment, and authority for that is also Pablo Star, paragraph 51. You needn't turn it up, but it's at page 150 of the authorities bundle. I should just say in passing, notwithstanding Mr Vatistas' submission to the contrary, Mr Vatistas does not have a direct interest in these proceedings. He is a shareholder in Tomini. That is the definition of an indirect interest in these proceedings. And Mr Vatistas said, well, Pablo Star's authority for the proposition that you need a direct interest. And Mr Vatistas has none. This wasn't a point developed by my learned friend any length, so I can take it very shortly. The tests for amendment and joinder intervention are importantly different and distinct, other than with very late amendments. Once you show a real prospect of success, you get your amendment. That's because as an existing party to litigation, you have a right to have any realistically arguable issue that you wish to please determined. As I've already said, in joinder intervention, clearing the real prospect merits letter is necessary but not sufficient, and I'll show you some authority on that in a moment. The authorities show that once you get past merits threshold on questions of intervention and joinder, the strength of the case is still a relevant factor. And that does not mean that it's a charter for the judge to conduct a mini trial. But as a matter of policy and principle, it's obviously sound that the judge should have regard to the strength of the case. Not to make fine distinctions, this case has this percentage of chance of success or that percentage of chance of success, but to say, is it a weak case, as the judge found Mr Vatistas' case to be weak, or is it a very strong case? If it's a very strong case, one can quite see that would weigh powerfully indeed in favour of joinder or intervention. So these are imprecise baskets of relative strength that the court can permissibly, I don't say must, ask into which basket does the case fall. And the judge here asked himself that question and said it's a weak case. And I would suggest that it would go without any supporting authority to say a weak case would weigh less powerfully in favour of joinder intervention than a strong case would. A barrage supports that analysis, and as Mr Vatistas has already said, a barrage is a curious case in some respects, but the satisfaction of the merit threshold was common ground, and yet the strength of the case came into the analysis at 39 to 40, 45 and 79 as paragraphs of the judgment.
Sorry, give me those paragraphs again.
Of course, I'm so sorry, my lady. So 39 to 40, 45, and 77 to 79.
Thank you.
Then the judge, as regards Mr Vatistas' position as a shareholder, did not take an absolutist approach and say an applicant who is a shareholder in a company that is party to proceedings should never be joined or permitted to intervene to advance a case in those proceedings. Nor do I take such an absolutist approach. In a case that is sufficiently compelling, joinder or intervention of a shareholder might be appropriate, but it's hard to imagine a shareholder case that would be sufficiently compelling where the shareholder could not say, and if you join me, I'll immediately apply to make a strikeout application. Because I've got all the material to show that this is an abuse. I'm ready to go, I just need to be clothed with standing, either by intervention or joinder, and then I can make the application. But that's absolutely not what Mr Vatistas was doing. Mr Vatistas was saying, join me on a wait and see basis, so I can run the shadow defence, and that is not appropriate. And Lehman in the authorities bundle at 185, paragraph 24, it is authority for the proposition that it's not appropriate to join a party on a just in case basis. 185, paragraph 24. There is an important distinction between this case and Pablo Star, which I will return in my submissions on ground 3, which is that in Pablo Star, the applicant was saying, join me so I can apply to set aside. As in, I've got the courage of my convictions, I've got the material I need to do it, join me so I can. As opposed to, join me because I say this is an abuse, but I don't have the material to justify a strikeout yet. And that's the proper analysis of what the judge did in relation to the availability of strikeout, or the orthodoxy of strikeout being a remedy for abuse of process. On then to legal principles, which again I can take relatively briefly given so many are common ground. What I've been calling the sprint room test, the sense in which an evaluative judgment must be wrong in order to be capable of being disturbed. Authorities Bundle 206 at paragraph 74 to 75. And at 77, this court quoted the Lord Hoffman statement in Barging, to which I've already alluded. If authority were needed for my first proposition that this is a challenge to a case management decision, it is in the decision of Azar, at page 276 of the authorities bundle, paragraph 30, that's just for your note, I do take that. Also as read.
That's Azar.
Azar, tab 13 of the authorities bundle, page 276, paragraph 30. Abdul Mahmood is the next case I was going to just briefly show you. 166 of the authorities bundle. Paragraph 27.
Sorry, we're in page 276.
I'm so sorry, page 166. Maybe.
166, thank you.
This is dealing with Lord Justice New dealing with the power under Rule 40.9 to set aside a judgment order, and Lord Justice New says the precondition that the applicant is directly affected by the judgment or order. It does not give the court, it does not empower the court to set aside a judgment order wherever it might think appropriate. The reason for showing you that is just to make the point in relation to 19.2. 19.2 isn't a free roaming discretion to join a party where the court thinks it's desirable. Either limb A or limb B needs to be satisfied.
And you rely presumably on the statement that in general the defendant should be left to decide for himself whether to defend a claim.
My lord, absolutely. That's the second reason for going to this case. It's a point that I made in open. So Tomini's decided to conduct the defence that it's decided to conduct, and it should in general be allowed to do so. And the ultimate result of the judge's evaluative judgment was that it should be allowed to do so without intervention from Mr Vatistas and his weak case. Sorry, I want to, Ms Thompson corrected me, this is a convenient moment. I'm so sorry, misspoke in relation to the 2015 credit agreement. I should have gone to the underlying evidence. Mr Vatistas did not sign that document, but he said in evidence it was executed without informing him. And that was shown to be false by the evidence that was put in. So it was executed after he was informed of its execution. So I'm grateful to Ms Thompson for that. And then I already have given a barge as one authority for the proposition that where a merits threshold is met, that's not dispositive in favour of joinder or intervention. And further basis for that proposition is the decision in Wise Payments. In Wise Payments, the judge dismissed a joinder application, including on the basis that the evidence to support the pleading was insufficient.
I'm sorry, I've lost Wise Payments.
Wise Payments is tab 15, page 310, is where I was going to go first, my ladies. Actually, on the previous page, the judge said they were going to apply the strikeout and summary judgment tests. Also cited the decision of this court, well-known decision of Lord Justice Popplewell and Kawasaki, to the effect that the pleading must be supported by evidence which establishes a factual basis which meets the merits test. That's further support for my point that mere assertion isn't enough in a case such as this. And then on to 310 at 37.1, you see that test being applied. And then at the top of page 318, you can actually pick it up at the very bottom of 317. Assessing the substantive and case management issues relating to his position overall, I consider that even if the first defendant's pleading and its factual basis met the bare test for having him, that's the merits threshold test. The cost-benefit considerations are not in favour of allowing to be joined. The issues are not entirely separate. I emphasise that. Both play a part in the overall balancing exercise. A weak case which will require significant work to make good, and which will entail additional complexity for limited gain, is less likely to be permitted to progress than one which may just creep over the threshold of being arguable. And so you see the assessment of the strength of the case and case management considerations about how it might be proved or how it might be litigated come into the evaluative judgment, and a conclusion that the merits threshold is cleared is not dispositive. Of course, a conclusion that the merits threshold is not cleared is dispositive. It's fatal to an application. And on to evaluative judgments. Having regard to the time, I don't have much to add to my starting propositions and my answers to the questions of Lord Justice Mayles and Lady Justice King in particular. The starting point is an appellant has a steep uphill struggle when challenging an evaluative judgment. A fortiori, if they can't point to a factor and say that was irrelevant, or that was a relevant factor that clearly wasn't taken into account. And then the prospect of further material emerging. I've already said why it's not open to Mr Vatistas, not argued below, not in the grounds. It's made for the first time in paragraph 39 of his skeleton core 148. As I've said, the concession that evidence is needed as to the nature of the documents that may come to light is itself fatal to this point. But I would make 4 further points. First, the judge cannot be fairly criticised for failing to have regard to a matter that no party raised or invited the judge to consider. That would not be a fair basis for attacking desirability of judgment. Even if the point, even if the point had been raised, it would have carried no weight absent evidence from Mr Vatistas providing reasonable grounds for the belief that disclosure may materially add to or alter the evidence relevant to whether there is a real prospect of success. That's quoting Harvey 128, Appellant, Authorities 252. I've already made the point, it has nothing to do with what witnesses Mr Vatistas might be able to unearth. The third point is that on a proper analysis, that Mr Vatistas' evidence tended to undermine rather than support the Harvey belief that more material might be out there. And the fourth point is the state of Mr Vatistas' evidence, and in particular his access to the documents. So Mr Patrokoulos just mentioned some things in submissions that aren't in evidence, and that's not good enough. But also, the submissions don't even acknowledge the fact that Mr Vatistas was a director of Tomini throughout the relevant period of assignment. And in his evidence at paragraph 49 of his first written statement, page 308 of the supplemental bundle, Mr Tomini says, he arranged for his Tomini email account to be deleted, but he retained a copy. So we don't have his emails, but he does. And he plainly has access to substantial documents because he exhibited almost 1,000 pages of documents below. And although he says it sotto voce or not at all, on his case he was a key participant in the scheme to defraud the Romanian revenue. So if there were a rich stream of internal communications, as was submitted by his counsel, he would be party to at least some of them. That point is not open to him and goes nowhere. Might that be a...
Yes, before we move on to the grounds. Excellent, thank you very much indeed. 2 o'clock, please.
For the correction.
Hello, you okay?
Jenny?
Yeah, yes, so you've got some audio issues.
Yeah, I hear it's something to do with the main judge. Apparently the
No, so
microphone's
I
not
can't hear this one. So when you put the text I could hear it.
That's what it is.
We weren't changing it.
Yeah, I have the microphone. So we just swap out
Yes,
the...
so it's my second. Yes, very much so, thank you. Yeah, I think I was about to pop, but that's okay.
Yeah, so Kirsten just can't hear anything.
You miss them?
Why?
The most important thing is they miss us.
Oh, that's good. You've done a good job.
Which was never the
Just
case.
wanted to go.
Yeah,
so to
okay.
get this
I'll swap the
sorted.
microphone. Jenny, I'm not entirely sure if this will be the solution, because I don't know if this is the reason it's not working. But the microphone has been swapped out.
Can you talk into it? So we can hear?
Yes, yeah. Judge microphone 1 check. Judge microphone 1.
You can hear that really well. Just when you did it, when it proceeded a bit forward, maybe it looked like it was off. I couldn't hear anything.
Well, this microphone doesn't have an on and off or.
Yeah, no, it's
Let's try again.
no, it's fine. It's I can hear you.
Judge microphone check 1, 2, 3. Judge microphone check. Check in first microphone. Check in first microphone. I also have free tablets with me as well.
Okay.
Because the clients have requested 14 minutes login.
I don't know why Kirsten can't hear me because I can hear it quite well. Okay.
Yeah, I'm going to need 2 minutes if that's okay.
Yeah.
Thank you.
Right. Yes.
Just double checking. Is this where you want the tablets to be?
No, I think can we have one first row?
On the
Actually, 1, 2,
so,
2 on the first row.
2 on the first row, yeah?
Yeah, and then the last one.
Okay, perfect. Yeah.
Okay.
I'm going to load up the TNX page, but obviously I don't know your login details.
Yeah,
so.
I can just open it.
Okay, perfect. Thank you for your patience.